Hello everyone. We have reached to the Council of Ministers, Article 74, which is thereby read to be as Council of Ministers to aid and advise President. Clause 1. There shall be a Council of Ministers with the Prime Minister at the head to aid and advise the President, who shall, in the exercise of his functions, act in accordance with such advice, provided that the President may require the Council of Ministers to reconsider such advice, either generally or otherwise, and the President shall act in accordance with the advice tendered after such reconsideration. Clause 2. The question whether any, and if so what, advice was tendered by the President to by the ministers to the President shall not be inquired into any court. About the Article 74, one states that President shall exercise his functions as per the aid and advice of the Council of Ministers. The words act in accordance with such advice used in clause 1 means that the function of the Council of Ministers is not just to give advice but to take decisions which shall be binding on the President. Article 74, clause 2 states that court shall not inquire into any question on such advice tendered by ministers to the President. In UN Rao versus Srimati Indira Gandhi, AIN 1971, it was observed by the Supreme Court that the real executive is the Council of Ministers and the President is merely a nominal head. Lord Morley described the Prime Minister as primus inter pares, first among the equals, but Sir William Werner Harcourt described the Prime Minister as interstellus luna minors, a moon among lesser stars. A moon among lesser stars. In Shamsher Singh versus State of Punjab, AIR 1974, Supreme Court reiterated that the President or Governor is formal or nominal head and has to act on the aid and advice of Council of Ministers. And this view of the Supreme Court has been incorporated in Clause 1 of Article 74 by the 42nd Constitutional Amendment Act 1976. The advice of Council of Ministers in appointment of a Supreme Court or High Court judge in Supreme Court Advocates on Record Association, AORA, versus Union of India, AIA 1994, the court held that in matter of appointment of judges of the Supreme Court and High Court under Articles 124 Clause 2 and 217 Clause 1, respectively, the advice of Council of Ministers must be binding on the President only if it is in accordance with the requirement of mandatory consultation with the Chief Justice of India. Article 75 talks about other provisions as to ministers. Clause 1. The minister shall be appointed by the President and the other ministers shall be appointed by the President on the advice of the minister. Clause 1A. The total number of ministers, including the Prime Minister in the Council of Ministers, shall not exceed 15% of the total number of members of the House of the People. Clause 1B. A member of either House of Parliament belonging to any political party who is disqualified for being a member of that House under paragraph 2 of the 10th schedule shall also be disqualified to be appointed as a minister under clause 1 for duration of the period commencing from the date of his disqualification till the date on which the terms of his office as such member would expire or where he contests any election to either house of parliament before the expiry of such period till the date on which he is declared elected, whichever is earlier. Clause 2. The ministers shall hold office during the pleasure of the president. Clause 3. The council of ministers shall be collectively responsible to House of the People. Clause 4. Before a minister enters upon his office, the President shall administer to him the oaths of offices and of secrecy according to the form set out for the purpose in the third schedule. Clause 5. A minister who, for any period of 6 consecutive months, is not a member of either House of Parliament shall, at the expiration of that period, cease to be a minister. Clause 6. The salaries and allowances of the ministers shall be such as Parliament may from time to time by law determine and until parliament so determines shall be as specified in the second schedule of our constitution. So appointment of non-members of parliament as ministers in Harsharan Verma versus Union of India AIR 1987. It was held that the appointment of a non-member of parliament as minister is not illegal. In SP Anand versus S.T. Devgoda AIR 97, the Supreme Court held that a person who is not a member of either House of Parliament can be appointed as a minister for a period of 6 consecutive months. We have read this case In the use case met, I guess.